I would like to welcome everyone to the 31st Bar, Media, and Judiciary Conference for the second year, presented with the organizational support of the Georgia First Amendment Foundation. I'm Richard Griffiths with the Georgia First Amendment Foundation. We have 3 terrific days in store for you. For the full rundown, you can go to the agenda published on the gfaf.org website. We'll post a link along with a link to bios in the chat feature of the Zoom interface. If you are a judge or an attorney seeking CLE credit, please be sure to identify yourself on screen by the name you registered by. Mom's computer or Jim's laptop as a screen identifier won't be good enough for tracking attendance. If you have questions for the panels, please post them to the chat. The Q&A feature is disabled for this conference. The panelists and moderators should be able to see the questions posted in the chat, and the moderators will do their best to get to them as time permits. Now I want to talk about the sponsors whose contributions go so far to support this conference. The names are now on the screen. I'll pause a moment to let those soak in. I want to give particular shout outs to the State Bar of Georgia, to CNN, the Atlanta Journal-Constitution, the Daily Report, the Council of Superior Court Judges and other judges' councils at the Administrative Office of the courts. This conference would not have pulled together if it was not for the tireless work of the volunteers whose names you see on the agenda. I want to particularly thank Peter Canfield, partner at Jones Day, who patiently guides this committee in the preparation of this event. You'll be hearing a bit from Peter tomorrow as he introduces one of those sessions. Now we'll turn to the kickoff event of the conference. I want to introduce Hyde Post, a longtime journalist and one of the founders of the Georgia First Amendment Foundation and of this conference. From St. Simons, Georgia, he'll introduce the terrific panel on the lessons of the Arbery case. Hyde, take it away.
Thank you, Richard. Good afternoon. Let me see if I can get my video to work. Today we'll be discussing takeaways from the Arbery case. It was exactly 2 years ago today that Arbery, a 25-year-old Black man, was out jogging in a neighborhood in South Brunswick, Satilla Shores. 3 white men in pickup trucks began chasing him through the neighborhood, yelling at him to stop, threatening him if he did not. At length, they cut him off. One of the pursuers, Travis McMichael, armed with a shotgun, got out of his truck and confronted Arbery. His father, Greg, who was also armed, brandished his weapon. In the confrontation, Arbery defensively grabbed the shotgun and Travis fired 3 times, killing him. For the next 74 days, very little seemed to happen on the law enforcement side, at least that most people, including me, who lives down here, noticed. 2 district attorneys and local police seemed to embrace the idea that the white men believed Arbery had been trespassing, that he may have been a burglar, and that the shooting was a case of self-defense. It's worth noting that Greg McMichael had previously worked for the local DA as an investigator. Then things changed. On April 29th, the Brunswick News published the text of a 911 call. It was made by Greg McMichael as the pursuit was underway. On it, he said, and I quote, "There's a black male running down the street." The dispatcher asked, "What's he doing?" "He's running down the street," said McMichael. "That's fine," the dispatcher said. "I'll get the police there. I just need to know, what's he doing wrong?" The dispatcher never really got an answer. Then in the next day or two, a video of the chase and the shooting taken by the third man in the group, Roddy Bryant, was leaked. I think it was to a radio station down here. And the leaker, as it turns out, was actually Greg McMichael, who believed the video would exonerate his son's self-defense claim. It did not have that effect. I first saw the video when it had but 300 views. It was just 2 hours later that the number of views was in the millions. The case was turned over to the GBI. The 3 men were arrested and indicted on murder charges in late June. They were tried in November and convicted. In January, they were sentenced to life in prison. This week, on Monday, they were convicted again. This time it was in federal court for hate crimes. To discuss this case today, we have a very learned panel that includes several folks intimately involved in the prosecution, in the defense and coverage of the case. Meg Coker, you can turn on your video, is editor-in-chief of The Current, a nonprofit digital news organization that focuses on the Georgia coast. She has a long background in investigative and international reporting for Cox newspapers, the New York Times, and the Wall Street Journal. She's also the author of The Spy Master of Baghdad, a compelling nonfiction book of Iraqi patriotism in the battle against ISIS. We also have with us Judge Lisa Colbert, a member of the Chatham County Superior Court bench. The judge was elected in 2020. She previously served as a juvenile judge in Chatham for 8 years. She's a UGA law grad and former president of the Port City Bar Association. She's also served as a committee co-chair for both the National Council of Juvenile and Family Court Judges and the Georgia Council of Juvenile Court Judges. We're fortunate to have with us as well Linda Dunikoski. She's a senior district attorney and head of the appellate section of the Cobb County District Attorney's Office. Linda was the lead prosecutor in the Arbery trial. She's a graduate of Georgia State College of Law. She began her career as a prosecutor with the Fulton DA's office, prosecuted a great number of important felony cases, and she was part of the team that successfully prosecuted the Atlanta Public School cheating scandal, which was Georgia's longest lasting RICO criminal trial. And we're fortunate to have Bob Rubin, who's been practicing criminal defense in state and federal courts for more than 35 years. He represented Travis McMichael in the Arbery case. He's an Emory Law School graduate and taught as an adjunct professor there for 25 years. He is also past president of the Georgia Association of Criminal Defense Lawyers. Thanks to you all, and thanks to all in the audience for making time for this. And I'll turn it over now to Meg, who will moderate the discussion. Remember, if members of the audience have questions, please put them in chat and we'll try and keep up with that if we have time. Thank you very much. Meg, it's yours.
Thanks, everyone. Really nice to see such an interested group of people across Georgia. In addition to my biography that Hyde gave you, I've also covered the state murder trial, and I have been in the federal court covering the federal hate crimes trial. So as just putting that out there for the record, as a proud resident of coastal Georgia, this has affected my life, this case, in a lot of ways over the last 2 years. But also for the record, I am a journalist, right? So generally, people like you and I are on opposite ends of this thrust and parry when it comes to covering criminal justice or any sort of justice in the state. And before we go into what I hope is going to be a lively debate and back and forth, I just want to get all of our panelists on the record for one major and critical issue. So I'm not assuming, and I'm not making my own driveway decisions about where everybody stands. So for all three, for Judge Lisa, for Linda, for Bob, The media were obsessed with the issue of race and the killing of Ahmaud Arbery, as well as this ongoing issue that we as Americans face about racial justice. So just before we start, could each of you, and we'll start with Linda, please, do you believe that that's a correct perception? Was the killing of Ahmaud Arbery and the media perception of that crime and the issue of justice, is it primarily focused on race and on America's conversation about racial reckoning?
Linda, you're muted. There you go. And
Yes.
Lisa, you can unmute.
The answer to that question is yes. Obviously, the federal hate crime trial has concluded and the jury came back guilty on all those charges. That evidence, while we did not put it in our case in chief because we didn't need to, as you know, for a state murder charge, the state does not have to prove motive or premeditation or anything along those lines. And we made a strategic decision not to put that into our case. But just looking at the case and knowing the evidence that was presented in the federal hate crime case about Travis McMichael, Greg McMichael, and Brian's attitudes, their explicit and implicit biases, their feeling that they were entitled to act in a vigilante manner and take the law into their own hands and do what they wanted to do in their neighborhood, all, I think, addressed this particular issue of racial justice.
Right. Lisa, what is your feeling on that question?
You know, it's interesting. I'm glad Linda mentioned implicit bias. You know, that is something that I have come to learn through my work, both at juvenile court and just as an attorney. Oftentimes, we don't talk about that. I mean, race permeates so much of what happens in this country, either systemically as well as on an individual basis. But it's often, it hasn't been talked about as much as it has in recent years. And I think it's important that we have those discussions because of implicit bias. Oftentimes, you know, everyone has them. I truly believe that most people may not be aware. So in addition to the explicit biases that we acknowledge, all of us have implicit biases. And I think that often what happens or doesn't happen in the justice system is influenced by those biases. And if not acknowledged and checked by those of us who are, you know, in charge of making sure the system is fair for everyone, those of us who are participating, either as, you know, jurors, witnesses, law enforcement, it can have some real consequences. So on the one hand, I'm sorry that we still have to talk about this, but I'm very glad that we are now talking about it because that's the only way it can be addressed to make the system what it should be.
Bob, was it right? Let's go back to, you know, the summer of 2020. Was it right for the media to be obsessed with race in this case?
Well, there's two different questions. Is it right for the media to be obsessed with race? Certainly, the time had come in America where we needed to address the systemic issues that permeated every aspect of our society. I truly believe the reckoning was rightfully coming. George Floyd had occurred, Breonna Taylor had occurred. Was this case about race? I'll take the contrarian view, and probably no surprise to people who know I defended Travis McMichael and say no. Does he have racial biases? Certainly, you know, from his social media messages, text messages, yes, he does. Does that mean he went after Ahmaud Arbery because of race? You can't correlate those two things without more evidence. So no, I don't think Travis McMichael targeted Ahmaud Arbery because of race. I think he targeted Ahmaud Arbery because Ahmaud Arbery was the guy going into a building all hours of the night, the building, the house down the street, with no explanation, and had been, and then was there on that Sunday. I think that's why Travis did. Is it a sense of entitlement? Yeah, I think you could argue that he felt entitled to stop suspected criminals in his neighborhood. Was that right? Jury found no, it wasn't right. Does it mean it was racially motivated? No, there is no evidence it was racially motivated.
So I'm going to pull us all back in time to May 2020, which is when, as Hyde recalled, that's when the video of Ahmaud's killing was made public, went viral. It's when there was an enormous amount of emotional speeches being made. Us in the media do not call politicians and get them to grandstand. Generally, politicians are grandstanding and ask us to attend those press sprays. One of the people making very emotional comments about the video was our governor, Brian Kemp. And Linda, could you speak to a little bit about what is a true and present double whammy, right? The nation is talking about a criminal indictment. The governor of the state is talking about the facts or the alleged facts of a criminal action. You get the case. How does a prosecutor deal with that amount of pressure, and how do you start to strategize amid all of that noise?
You ignore it. That's what I did. Well, first off, the timeline, you got to realize it came to us, meaning the Cobb County District Attorney's Office, on May 11th. So it was February 23rd of 2020. There had been numerous media reports. The video had been leaked by Greg McMichael. There was a response to that. The GBI had been assigned and they started their investigation May 6th. Arrests were made May 8th. May 11th, it's assigned to the Cobb County District Attorney's Office. At this point, of course, we don't have anything. And what most people don't know is that often, for instance, a homicide that takes place in Cobb County, we're called out, meaning the District Attorney's Office is put in touch with the police officers. We work with them. We help guide them. We brainstorm. We do all kinds of things to help them build their case and build it correctly, meaning please arrest the right person. That's what we want to have happen here. And so in this case, of course, Cobb County is very, very far away from Brunswick. And we came in late, so late that the evidence in the case, meaning the video, had been released to the public for everyone to see. So back to your question of how does this double whammy affect our strategy? For me, it did not. For me, this was a homicide case. We needed to look at it. We needed to decide if the GBI and law enforcement had gotten it right by reviewing the evidence, because that's what you do as a prosecutor. You review all of that evidence. We had to go to the preliminary hearing first. And remember, this is all under COVID. So of course, we haven't met with anybody face-to-face. We haven't been able to, go over to the law enforcement's office or meet with the family face-to-face. We haven't been able to do any of those things. So we have to analyze it. And we did that. We got the GBI file as it was at that point in time, did the analysis, moved forward to the preliminary hearing. And for me, I really took it seriously in the sense of we needed to be fresh eyes on this. And therefore, the noise or the outside voices were not going to have any impact on our charging decisions. And that's how we all felt about it, that we were being brought in for that reason, to give it that look that was unbiased and just a clean look at the case.
And you feel like you had the freedom to do that. You weren't getting phone calls from the state attorney general's office. You weren't getting phone calls from outside of your jurisdiction, from people who had, political points that they wanted to score.
No, we once it was assigned to our office, there was a phone tree. And yes, my phone burned up. I stopped answering my phone because they had a script, and I found it incredibly inappropriate in the sense of you're calling up the district attorney's office and trying to tell me what to do. Okay, and trying to tell Joy at Holmes, the elected, what to do, and trying to tell this team what to do. So all those voicemails got put into a folder, and that was that. And we didn't listen to them because our job as prosecutors is to make sure that everyone did their job right, make sure that the law enforcement did their job right, GBI did their job right, to review all of the evidence in the case and then make an appropriate charging decision.
Right. So Bob, by the time you probably met your client for the first time, he and his father were being billed as two good old boy white racists. you had a steep, a pretty well-defined narrative that was out there about them. Why did you and your law partner decide to take this case?
That's what I do.
But this wasn't every case, right? I mean, you probably had some competition for your time and your billable hours.
So certainly didn't take the case for the money. There wasn't a whole lot of money involved in this case. We made a decision early on not to solicit funds because we didn't want to get funds from groups that we didn't personally agree with. But I viewed this case as the call came to me on Mother's Day. So I had to ask my wife if I could have permission to take the case, and then ask my kids if I could have permission to take the case. And even though they said no, I took it anyway, and had to convince them later. I took the case because it's the Super Bowl of cases. Even though I turned out to be the Atlanta Falcons of the Super Bowl, it was a once in a lifetime experience. And forget the media noise, all the other things. It was just interesting. I never had a citizen's arrest case. I didn't know much about citizen's arrest. I knew the prosecutors on the other side, like Linda, who I'd spent a lot of time working against but with. I thought it was just going to be the experience of a lifetime, and it was.
So was this, I mean, I guess it was the most high profile media case that you've taken on in your career.
It was. And I thought I was in the APS case, the Atlanta Public School cheating case as well, against Linda. So I'm 0 for 2 against her. And I thought that would certainly be the highest profile case I would ever have. I had not been involved in anything like this. And I think very few lawyers have. Either you're in the George Floyd case or you're in this case. Those are the two cases that seem to have this kind of attention.
Yeah. Lisa, this was a case that was covered gavel to gavel. I'm not someone who watches court TV or reality legal shows. As a judge, is that something that you go home at night? Do you turn on court TV or legal dramas to help unwind? What do people in the profession think about those 24-hour wall-to-wall coverage legal programs?
Well, I think it varies. I can't speak for all of my colleagues, but I, for one, do not unwind watching court TV. I don't even watch Law and Order anymore. So no, but I do think it's important though for public access, that the public has the opportunity, they have the right to be able to view what happens in the courtroom. I do worry, I just have to say this, the impact that it may have sometimes on jurors. The concern for their safety, concern for their anonymity, concern for what may happen if they reach a verdict that, large sectors of the public don't agree with. That's the only concern that I really have about the public access, other than some subject matter when it involves very young children and maybe their victimization, or in my custody cases, because we live stream here in Chatham County for the most part. And so there are times when I'm concerned because of the parties involved and the impact it may have on them, but also for the jurors.
Do you think that your fellow attorneys in the state or in America, do they behave differently when they know that they're being live streamed, or they know that there is a camera in the courtroom?
Is that for me, the judges, or the attorneys? Judges?
Both. You're a keen observer. Let's start with judges and then go for attorneys.
Well, I can tell you, so I came from juvenile court, and while most of the hearings were public, when I left during the pandemic, we were not live streaming. The access, we had still come to the courtroom. I do know, I don't know that we act differently. I think you recognize that there may be many folks watching. I will say one of the things that concerns me is when we sequester witnesses, hoping that they are not watching live stream while they're sequestered. But yeah, there is some nervousness, I would have to admit. It's far different than when you look in the gallery and you know who's in the courtroom, not knowing who's watching, how many are watching. So yeah, it is a little nerve-wracking at times. I've been amazed at how many people have been watching hearings that did not appear to be of any public significance, but people are very interested. I think because of some of these high profile cases, people locally want to see more about how the local courts operate. How do the judges handle themselves? How do they handle the cases? And it's the subject matter. So I think it can be a little nerve wracking. I think for most of the judges, I'll be quite honest, probably get more nervous because our families for the first time, I have children in school all over the country and they're watching at times when they have a moment. And so that's quite interesting because typically they have not been in a position to see me at work. Mm-hmm. That makes sense. Or my mother, for that matter, who's retired, and she and all of her retired friends are watching all of the judges here. So it's quite interesting.
That's funny.
Yeah.
A little bit more on a more serious bent, though. Do you each? I'll start with Judge Lisa, but ask all three of our panelists. Is there a trial that you in which you believe that the media has actually helped to warp an outcome, but either positively or negatively, helped create justice or helped to perpetuate injustice because of the media spotlight on a case? Is there something that stands out for you, Judge Lisa?
Not in particular. I've never had the opportunity to really interact, with jurors after, like for the jury trials that I've had here, since we've been live streaming, to see if that's had an impact on, how they view the case or the decisions that they make. I'm not aware of any cases locally where that's had an impact, that the media has been broadcasting or that the case has been cast on live stream. I'd be curious whether those who participated in the Arbery case feels that way, given it was probably one of the most high profile cases in my lifetime. I was around when Rodney King, that case was tried, but I don't, I don't know how that compares in terms of the amount of newsworthiness or media coverage compared to the Arbery. But I'd be curious whether it had an impact on jurors. That's something I'm not able to answer.
Right. Linda, what about you? I mean, in general, is there a case that stands out to you in sort of recent history that media you think has helped warp the decisions? And then we'll talk specifically about your murder trial.
The answer is no. I cannot think of any case where, because you use the word warp, and that's kind of, the intimation there is one of, well, there was something untoward that went on due to the media or due to media coverage of a case that somehow affected the verdict. And as you know, jurors are instructed repeatedly, do not watch this, do not talk about it, do not discuss it with your family, do not go home and get anybody else's armchair quarterback opinion about your particular case. And they're instructed that every night. I know APS, they got instructed that every time they went home. I know in the Arbery case, they were instructed the same thing by Judge Walmsley, not to discuss it, don't look at anything, and over the weekends, don't watch any media or news or anything, so they would inadvertently look at anything. And I do know that when that has happened, where a juror during deliberation has come in somehow having researched something themselves or asked somebody else, a buddy in law enforcement, and has reported it to the jurors have actually reported it to the judge. And we've had that happen on a few occasions, at which point in time, what we usually do is bring everybody in individually and ask each juror, has that affected your ability to deliberate and base your verdict solely on the evidence from these four walls, or are you taking that into consideration? Can you put it aside? And we have to do that. And some jurors can say yes. And I've had a case where a couple of jurors went, no, they couldn't. We had two jurors who just went, one went to the scene and one went and asked a buddy. And that case ended up in mistrial, as it should have, because the other jurors said, no, they came in and they told us all this stuff that we didn't know, but we really just can't put that aside. So the justice system does work. And when jurors are instructed, they do the right thing and report to the judge when something has gone wrong. So I can't think of a case that's gone terribly wrong where it didn't end the right way in a mistrial.
Right. Bob?
We're being deliberately or naively ignorant if we don't think the media coverage affects outcome. Studies show that negative pretrial publicity directly affects jurors in the way they ultimately vote in a case. This case, in particular, the Arbery case, had unbelievable coverage prior to the beginning of trial. I'm not saying the jurors did anything improper during the trial. I, like Linda, believe they tried very hard to do their best and to follow the instructions. What I believe is that the negative pretrial publicity prior to trial unavoidably and irretrievably broke the system in this case. I don't think there was any way we were going to get a open-minded jury. And I understand we tell the jury to put their side, their thoughts and opinions of what they think they know about the case. And we are essentially asking them to do the impossible. And research shows it. I mean, it's naive for the legal system to pretend that that actually happens.
So let's go to the video, right? Let's talk about your strategy. So it's out there. It's been seen by millions, including vast numbers of residents of Glenn County. How do you, as a zealous and rigorous defense attorney, then prepare? How do you mitigate what you see as damaging media portrayal?
Right. So I like the way you phrased the question, because honestly, I viewed that video before I was involved in the case. The case was already in the media. I didn't really know what people were talking about. And then one day, I don't remember, I guess it was early May, I Googled it and saw the video. And I saw something very neutral. I saw a man running towards another man holding a shotgun. I saw the man running towards the man, went around a truck and grabbed the shotgun when the shots were fired. I didn't know what had happened. I knew there was a lot more to that story. What the media was portraying, because the family put it out there, was that, and this is what Hyde's introduction actually touched on, was that the man running down the street was jogging. And that was the narrative throughout the 18 months for my involvement until trial. And yet there is no evidence that Ahmaud Arbery jogged in Satilla Shores. But the family said he was jogging, so that's what was portrayed in the media. And that colored everything, because all of a sudden he's just an unarmed jogger out looking for a peaceful Sunday afternoon jog, and three rednecks stop him for no reason whatsoever and shoot him inexplicably. And that's not the facts of the case. So to your question of how do you fight against that? How do you push that boulder up the hill? You talk to journalists. I talked to Bill Rankin at times. We were on his podcast at times. We talked to Richard Fawcett with the New York Times. I talked to whoever was willing to give me a fair shot at telling my side of the story. Those that were not willing to report on the case honestly, I didn't talk to. And I tried to get our side out there to just not to warp the jury in my favor, but simply to try to open up some minds. And when we had our first press conference, that's all we asked of people, is just hold on, let the case play out in the courtroom, and let's see what the evidence actually is, and not jump to the conclusions that the media had already jumped to at that point. So
what does that media spotlight do for the cost of a rigorous defense? You're pushing a boulder uphill. What added costs and do you have in a case like that? Zero.
I mean, the cost doesn't factor into it. We had the ability to run through a local PR firm the number of articles that had been printed and broadcast in Georgia, which was important for jury selection purposes. But we don't hire a PR person. We're not paying anybody to do anything special about the case just because of the media. We're handling it ourselves. We're doing the best we can to be open and honest with the media. We were on, and Linda, you guys were on that show too, early in the case, the news magazine show. I don't remember what, not Dateline, not 48 Hours. Was it 48
CBS.
Hours?
It was CBS 48 Hours. Yeah.
So
it wasn't me, by the way. It was Jesse.
No, it was Jesse. Yeah. And we were on that show because, again, you go into an interview like that, they give you 3 hours of their time to talk about the case, and then they play 5 minutes of what you talked about. And after that, we just throw up our hands and say, you know, what are we going to do? So,
Yeah, you just need to trust print journalists more than TV. That's personal bias there. Okay, so let's move forward to jury selection, right? If everybody has put their thoughts on the record about the issue of race and this trial, but jury selection brings up race in a way that we probably all should talk about. And I know Linda and Bob, you are on opposing ends of shaping that jury. So Linda, what strategy did you have going into jury selection? What was the makeup that you were looking for, or you were trying to, what was your ideal jury that you wanted? And how close did you get to it?
All right, first off, everybody gets jury selection wrong. We don't get to pick the jury.
Sure, I said
Okay.
shape. I said shape, right?
Yeah, we don't even get to do that. What we do is we are looking for fair and impartial jurors who are actually willing to base their verdict on the evidence that they hear in the four walls of that courtroom, follow the law that the judge gives them. And in this particular case, we actually, both sides began asking them, will you give real meaningful consideration to the defenses of self-defense and citizen's arrest? Because if you're not even willing, and we had, I think, Bob, at least 3 people went, yeah, I'm not paying any attention to that. And they got booted. Okay. But that's the whole entire point of the jury selection. So first off, the first hurdle that I think everybody had was self-deselection. And nobody talks about that, but we had a lot of jurors who very honestly came in. And despite saying, oh, I'm willing to base my verdict on the evidence, I'll follow the law the judge gives me, but I'm not going to consider self-defense because I watched the video and that's not self, whatever they would say. They self-selected themselves out. And we had a lot of jurors, and we needed that. We needed them to be honest and tell us what that implicit and explicit bias was that they had, and if they'd already made up their mind about the guilt or innocence of the defendants. So when you say shape or select the jury, what most people don't understand, because I get it all the time. After every homicide trial, I have jurors come up going, why did you pick me? And I'm thinking, I didn't pick you. You were left over. After the defense said, I don't want these people, and the state says, I don't want these jurors for whatever reason, the 12 or 14, because you usually have 2 alternates, they're the leftovers. They're the ones that the state and the defense didn't have a race neutral reason for going ahead and striking. So those are the jurors you end up with. So from the state's point of view, walking into the big long process, first off, Judge Walmsley did an excellent job of giving us enough time to explore our jury panel. That is, I have to say, I do have a problem. A lot of our judges go, we're going to pick this jury in one day. And I don't know why they do that, because then they end up with a hung jury, and then they're often like, I don't understand why it's a hung jury. And I'm thinking, well, we didn't get to do a good enough job talking to these folks. So I really like the fact that Judge Walmsley gave us, 3 weeks, thoroughly went through 20 people a day. And we, meaning the state, I know, we just wanted people who were going to be fair and impartial and listen to the evidence, because we felt very strongly about our evidence, and we felt very strongly that the law was on our side. And all we needed were people who were going to listen to it and follow the law.
Certainly, I get all that. But are you really saying that demographically you didn't care that there were 8 women and 4 men, or that you wouldn't have wanted a gender balance that was different, let alone a socioeconomic balance that was different, or a racial balance that was different? Ideally, in your wildest dreams, what would you have liked the jury to look like?
12 of me. I'm the most fair and impartial person I know. I can analyze a case in a heartbeat. I can read the law. I get it. And yes, I'm a prosecutor, but that's how I feel about it. Am I ever going to get 12 people who are me? No, of course not.
12 prosecutors on a jury. Yes, that sounds
right.
Excellent.
You're never going to get that. So that question I appreciate, but the answer is that has never, ever been my experience of an ideal jury. You are going to get the best jury you're going to get. One of the things that people also haven't talked about is the fact that, unfortunately, in Brunswick, Glenn County, they had a 40% return rate, meaning every 100 jury summonses that were sent out, only 40 of those 100 people actually came to participate in jury selection. In Fulton County, they've taken care of that. That's downtown Atlanta. And they have put a system in because they had so few jurors coming in, and they had a lot of trouble with that. And they took some remedial action to make sure people were actually showing up so that you would get a big, vast cross-section, both socioeconomically, gender and race and everything in downtown Atlanta. And that worked really, really well. So I don't know if I've answered your question appropriately, but that's what I've got.
Good. So Bob, over to you.
Yeah.
You had an extra challenge in that there were three co-counsels for the defense, and you have to play as a team, don't you? I mean, tell us how the tactics were going for defense strikes.
So the judge was really very good to us in the sense that he gave us, I believe, 24 strikes and the state 12 strikes. So he gave us twice as many strikes as the state, which is very unusual these days. That's how it was when I first started, but the legislature changed the law a while back, and usually they're equal. We needed every single one of them. I mean, this was a case, honestly, the media aside, this case was just a regular old case that we've tried before, in the sense that it's a murder case. We've tried murder cases. What made this case really stressful and kept me up at night was the reactions of potential jurors during jury selection. I had not tried a case, even the APS case was not like this, where potential jurors came in knowing so much or thinking they knew so much about the case and having such a negative opinion about my client or Greg McMichael and my client. Fortunately, we worked very closely with Greg McMichael's attorneys, Frank and Laura Hogue, and every night after the day of jury selection or questioning, we would come back to the Airbnb and spend the next couple hours going over what had happened that day and talk about the next day. So we worked very well with them, and honestly, Roddy Bryan's counsel was willing to let us do the heavy lifting and was willing to abide by the decisions that we made on potential jurors. But to have jurors 20 a day or whatever number it was, on particular days, most of them, at least in their questionnaire responses and initial responses, thought our clients were guilty. And that was hard.
And so the moment of jury selection that stands out, of course, is the racial one. 11 of 12 strikes, you guys correct me on the record, 11 of 12 strikes were against Black potential jurors, qualified jurors. Judge Walmsley made a point of saying that he believed there was discrimination as part of the strategy of defense, but that case law prevented him from reseating any of those jurors. What's your reaction to that, Bob?
I thought Judge Walmsley did a very good job, as Linda pointed out, giving us the time and space in jury selection to question these jurors. And I thought it was totally inappropriate for him to make that comment, and downright dangerous for him to basically speak to the crowd. If he thought that we exercised our strikes in a way that was based on racial biases, he should have reinstated the jurors. But to say we did it and then not reinstate the jurors and say Batson prevented him from reinstating the jurors is absolutely wrong. Because once the state made out a prima facie case, we provided race-neutral reasons. If he didn't believe those race-neutral reasons, reinstate the juror. But to try to have it both ways and follow the law and yet call us out as racists in a trial like this, I thought was totally inappropriate and downright scary for us.
Judge Lisa, the Judge Walmsley cited Batson as saying that his hands were tied. I don't want you to speak directly to that case. That's not your case, but talk to us about the law. Talk to us about the law today in Georgia and whether it's adequate for addressing the perception of racial bias in jury selection, because different states and different areas do it differently. Am I right?
Yeah, I imagine, I'm not a fan of the peremptory strikes. Quite frankly, I just wish all strikes were for cause or not at all. But obviously I follow the law because I think you can come up with, and not speaking to this case at all, but it's not terribly difficult to come up with a race neutral reason to support a peremptory strike if you're, accused of using those strikes to discriminate. So I don't know that there is a way to avoid in a situation where someone does want to, for whatever reason, strike folks who look a certain way or because of their gender. So it's an interesting law. I mean, and I think, again, going back to what Linda spoke to earlier, implicit bias is real, and not very many people are aware. I've spoken to many people about this, and thankfully been exposed to training on that issue through my time at juvenile court. And it's really real. I mean, those of us who believe we don't have any, when put to the test, we discover that we do. I haven't met anyone who's taken either of those tests who has walked away and said, oh, I had absolutely no biases. And so when you look at that in the context of selecting a jury, even in a case that isn't racially charged or doesn't have race as a potential issue, I think that can always come into play in one's decision about why this person, should be weeded out over someone else. Mm-hmm. So I think it's a real problem.
Okay.
If I can jump in.
Please.
Okay, so here, just addressing a few things. First off, Judge, you're absolutely right. Getting to those jurors with that implicit bias, that's what the peremptory strikes are for. And we used, out of our 12 strikes, 8 strikes we used. Those people weren't struck for cause, but 8 of them were because they knew the McMichaels or they knew Brian. And so I was forced out of my 12 strikes to use 8 of them on people who actually knew personally, either knew them well or knew them peripherally. So I had to get those people off my jury, which is one of those things where they're not going to be honest about their implicit bias about the defendants. I have to internally use my spidey sense, and that's what those peremptory strikes are for. And then with regard to Batson, and Bob, I may be remembering it wrong. What I thought Judge Walmsley did was that he found that the state had made the prima facie case of racial discrimination. And the way he said that was because we did the math. And it was basically, and lots of people ask me about that. Well, how did he find that? And my explanation has always been, well, it's just the math. The first hurdle for the state is always on a McCollum challenge or a Batson challenge from the defense would be the math alone. And in that particular instance, what I thought he had done was he had said, based on the math alone, the state's made its case. And then Laura Hogue took over with the race neutral reasons. And then he said, I don't find racial discrimination. That's why I'm not reseating anyone. And maybe I'm remembering it wrong. And I know the record will be what the record is, but I thought it was more, there was no finding of racial discrimination after the defense had given their race neutral reasons.
There was no finding of racial discrimination because we didn't discriminate on the basis of race. We had reasons for each juror being deselected. What he said was not that the math supports a prima facie case. Can't argue with that. I mean, our strikes were used the way they were used, but he went beyond that and he played to the damn gallery. And it created such a firestorm for us that we increased our, I wouldn't say security because we didn't have security. We increased our awareness of our surroundings as we're coming and going around that area. He basically said the strikes were used in a racially discriminatory manner, but because we gave racially neutral reasons, he was forced, much to his dismay, to support our reasons for striking the jurors. Well, that's.
I don't remember him saying much to my dismay, but
no, that's my editorial. Yeah. He indicated his dismay at, oh my gosh, I'm forced to agree with the defense in this case. And you know what? Just do your damn job, because that creates a problem down the road. I thought it was irresponsible.
Well, let's talk about playing to the gallery, because generally prosecutors and defense counsel are also guilty of that charge as well, right? You have 12 people that you need to convince. In the case that we're talking about, you had a whole state of Georgia that was watching and the whole nation was looking on. Bob, talk to us about, again, tactics. You're working with co-counsel. Everybody has their own personality. Everybody has their own level of experience. Everybody probably has their own sense of wanting to do things. And tell us about that. Tell us about how the trial starts. And if you guys, I mean, what do? Do you constructively critique everyone? Do you go in with a game plan? Do you have a script that you're looking to follow in terms of the personalities that you're portraying and the points you're trying to score?
Well, I just want to be clear. We're playing for the jury. We're not playing for the gallery or the media or the world that's watching. And that is an important distinction. And I'll just speak for the attorneys for the McMichaels, because counsel for Mr. Bryan was kind of a different, maybe had different tactics. We are all very experienced lawyers. Probably combined, we have 120 years of trial experience. We also have our distinct personalities. I'm not going to be fire and brimstone in the courtroom. Frank Hogue is not going to be fire and brimstone in the courtroom. We have our set ways, and we do the best we can with what we have. We did talk through approaches to witnesses, what would be effective. You're not a trial lawyer if you're not thinking of the theater of it, of the drama of it, and how it will play to the jury. But we tried very hard not to play to the media. And in fact, I know one time in particular, I made a speech to all the lawyers not to say things in a way that would create this firestorm out there in the world that we had to go through each day and night, but to keep the keep the pot from boiling over. And speak responsibly in the courtroom because people are watching and reacting to what we're saying. So we are, and Linda's a master at this. Linda did a very good job with her theatrics in the courtroom. And I don't mean that in a pejorative way. I mean, a trial is theater. We did the best we could on our side.
How would you describe Linda's theatrics in the courtroom? Linda.
Hello. She is very animated and very good at connecting using simple, not simple language, but using layman's terms and simplifying things so that a jury will get not just the law part of it, but the emotional part of it. And she's very good at tapping in the emotion of the case and did a great job in this case.
Linda, you came into court with your own team that was very diverse, right? Multicultural, multi-generational. What were you thinking about putting that team together and bringing them to Glenn County to try this case?
Boy, my team was fabulous. We had a great chemistry. Larissa, we're practically the same person. And once you become a roommate, you realize, oh my gosh, you are just like me. We read the same books. We liked the same food. That sort of had the same thoughts about the case. In fact, it was Larissa and I and Paul sitting around brainstorming together that we eventually got around to driveway decisions. And that was a result of the three of us just, I have to give Bob some credit. We were angrily discussing the defense. And we came up with this whole that's where the decisions were actually made. It was bringing all the different experiences together and sitting around and brainstorming and mind mapping, and such a great team to work with. I just loved working with them so much.
But the jury is from Glenn County and you all aren't. Did you have any preparation amongst yourselves, in terms of your own script or your own personalities, what you were going to show Glenn County residents versus the big city of Greater Atlanta?
Yes. So I have always practiced Cobb County and Fulton County, which is Metro. And I talked to a lot of people. In fact, a good friend of mine, he actually grew up in Glenn County. So I called him and he kind of let me know what the deal was down there. And we, of course, went down and we met with people. So we did a lot of checking it out. When I talked to Marcus Arbery, one of the first things that he ever said to me is, this is not Glenn County. This is not who we are. I can't believe this has happened, not only to me and my family, but this is not who we are. And people are going to think this is South Georgia and Glenn County and Brunswick, and this is who we are. And this is coming from the father of Ahmad. So I'm like, okay, so we've got a disconnect here. What's really going on? So we go to Satilla Shores, we drive around, we see in 2020 before the election, Trump banner signs everywhere. And one, I run with the mod sign, and that was kind of it. So we kind of had a different perception. We had a perception of this is going to be tough, okay? That not everybody was going to see this the way we saw it, that they are going to feel this was justified and it was okay for the McMichaels and Brian to do what they did. So in preparation of this, I actually found this book called Alienated America, written by a journalist. And it was one of the most interesting books that I have read about why some people think America is great just the way it is, and why others ascribe to make America great again. And what we realize is Brunswick was kind of one of those places as a seaport town, a town that it has a ton of business because it's a port city, but it has a very diverse, kind of socioeconomic strata. Not everybody's here. Everybody's kind of from here all the way down. So yes, we did a lot of thinking about Brunswick and a lot of thinking about how do we come in from Metro Atlanta and talk to people who are from Brunswick. And we were concerned because when we've done that in other jurisdictions, defense attorneys, and it didn't happen in this case, but defense attorneys have often gone, they're not even from here. Why would you listen to them? That kind of thing. But we didn't really encounter that, given that Rubin and Sheffield were from Decatur and the Hogues are from Macon. I don't think Mr. Goff really could throw that kind of around. So, but we did do a lot of thinking about it and how to present appropriately. So.
Yeah. Judge Lisa, playing to the gallery or playing to your constituents. I mean, in Georgia, Superior Court judges are elected officials. How does a judge work that out? That you are there to be the arbiter of the case in front of you, but you also are going to go through an election cycle, and people are going to remember who you are, what you did, what you said.
So it's interesting, having recently run a contested race, I guess not quite 2 years ago, I told people when I ran and met with people, you're not always going to like the decisions that I make. The best I can tell you is that I will always do my best to be fair, follow the law, treat everyone who appears before me with respect. So you have to just not listen to all of that noise. Oftentimes I've had to make decisions that personally, I wish I didn't have to make. And that's just part of being a judge. And I know that many people in the public may not understand that, but I think if they understand that you are being fair, and let me just say this, one of the things, I used to be a staff attorney for one of the judges here for about 8 years when I was much younger. And one of the things she told me, Louisa Abbott, you always write your decision for the party who loses. The party who wins doesn't really care why they won. But the one who loses wants to know that you heard their arguments and that you had a reason for why they're not getting what they want. Obviously that doesn't happen in a jury trial, but when the judge is the trier of fact as well as law, I really have taken that to heart. And I have learned in the almost 10 years that I've been a judge now, that has helped people understand, why you ruled the way you did. And I think adds a level of transparency, gives them the ability to see that you were trying to be fair, just that the law and the facts may not have been on your side. So it's a difficult thing. There are times I wish that judges were not elected. Some states they have retention elections after judges appointed by a legislative body. I don't know of a perfect system, but it's just a risk we have to take. I think if you're doing this work the correct way, you have to make the right decision, wherever the law and the facts take you. And there may be political ramifications, but I think it's a problem if judges let that sway them in any way.
Right. So the ruling came down in the Arbery murder case. And Linda, you represent the state. You also are the advocate for the victim's family. Bob, you represent your client. How, when you hear the ruling, when you go back into whatever conference room you were meeting them all in, what do you say? How did get us into that moment of working with the respective families to help them process what had happened. Linda.
And do you mean the verdict itself, or do you mean just the motions, hearings, and the rulings? And as
No, we mean
through?
the verdict. Yes, excuse me. Yes.
Oh, that's okay. It was really, really emotional. As you know, Marcus Arbery had to be taken out. He was so overcome with emotion. And so it was very, very emotional for the family. They were surrounded by people, loved ones, and Ahmad's sister was there. So just family and everything. We gave them their space and their time because it was very, very intense. And then we joined them in the jury assembly room just to check in, and there was lots of hugging and lots of crying.
Mm-hmm. Bob, how did it go for your clients and family?
Well, the conversation begins before the verdict comes back. So throughout the trial, as you're dealing with your client, any client, not just Travis McMichael, you're talking about the ups and the downs of the day and what to expect and what to hope for, and best case scenario and worst case scenario. And so Travis was properly prepared to receive a verdict. Were we disappointed? I mean, that's an understatement, but he was very stoic. He was very strong. He, was not angry. He didn't show any anger anyway. He, I think, prepared himself for that verdict. We don't get to spend a lot of time with them. Typically, the sheriffs will whisk them out, take them back to the jail, especially in this case where there's a lot of people outside the courthouse at that time. In fact, we had to stay inside the courthouse for a while and let the family have its time outside, and just to keep things safe. And so we went to see Travis the next day and kind of just talk through it. And he, honestly, he was very strong. He understood. He understood what the steps were. He knew what the ramifications would be for him, and did not display a lot of emotion at that time.
Mm-hmm. Hyde, I am not paying attention to the chat as I'm engrossed in our conversation here. I have several more questions I can ask, but let me throw it back to the people in the audience. Are there some questions you can?
There are a couple. I'll ask them. I think everybody could weigh in on them, but we'll start with Linda. We had a question about the House Bill 479, the bill that modified the citizens arrest law in Georgia. That happened after the crime was committed. How would that have changed the dynamics if it had been in effect before the crime was committed, or would it have had an impact?
So when you're talking about modifying the citizens arrest law, is that what we're talking about?
Yeah.
I think one of the things that we all discussed, when I say we all, I mean both defense attorneys and the state, was the fact that it had not been modified in years, like years, and it was mostly used as an affirmative defense, primarily to shopkeepers for false imprisonment when they caught somebody stealing from them. And so that's where you found most of the law. Kevin Goff, the attorney for Mr. Bryant, wrote an unbelievably thorough brief on citizens arrest law, having looked into every aspect of it. I myself also had to look into every aspect of it because, of course, we had to write up jury charges. So it was very, very written very poorly, I think, and that created a problem because I know as we both tried to argue it during closing arguments, Frank Hogue motioned for a mistrial because he said I was misexplaining it. So I'll let Bob talk about that too.
One more question before we move on to Bob.
Sure.
From your vantage point, have the changes that were made been good changes? I mean, do you think
Yes, it's clarified it.
Yeah.
Right. So the changes to that needed to take place, and we have been moving in that direction. A lot of the older statutes have been updated, they have been reviewed, they have been modified, and the language has been improved with the time. just no one ever got to this one. And I think it's happened now, so I think it's a good thing.
Bob, what's your take?
Well, the citizens arrest statute in place, in effect, at the time of the shooting and the trial, well, not the trial, but the shooting, was a codification of the common law prior to 1850 or something like that. That was the oldest case I think we found, was 1850 or 52. In 1863, I think Georgia codified all of its common law. So again, when the media referred to it as a Civil War era statute, implying that it was enacted for the purpose of racial animus, they're wrong. It was actually in place long before the Civil War, but just in the common law form. The statute was unbelievably poorly written. We spent months trying to dissect it, understand it. I mean, Linda, I know, did the same. We were all struggling with the seemingly two sentences that didn't follow one another, and trying to figure out why were there two sentences, where was, it just was poorly written. And it became a bone of contention at the charge conference and in closing argument, and maybe a point of appeal. But the new statute is much better. It's much more limited in who can use it, and it's much more, it's much better written.
Judge Lisa, do you have a view on the?
No, honestly, I had not followed that statute much. Surprisingly, I haven't had any such cases, or maybe not surprisingly. So, no, so I have no comments to add regarding that.
The same person asked this kind of hypothetical, and that is that if Arbery's murder case was retried and the race and gender of both the victim and the defendants were never revealed, do you think the jury would arrive at the same conclusion? So that's kind of hypothetical, but I'll put it out there. Linda?
The answer is yes. If everyone were green, what they did was illegal. You can't go chasing somebody down the street with shotguns, falsely imprison them on the road, try and run them off the road with your pickup trucks. So if everybody had been the color green, my opinion is they would still be found guilty, because what they did, no matter what color, race, gender they were, what they did was illegal. And that was the entire point of the state's case.
Bob, do you have any thoughts?
I have no clue. What might be more interesting question is if the case was treated like any other case, and were tried, whether the race of the victim and defendant remained the same or not, but tried without the media coverage, would the outcome be the same? And that, I think, that's an interesting question, because I'm not sure it would.
Let me ask you one more, since I have the floor for the moment.
By the way, can I interrupt real quick?
Absolutely.
Bill Rankin pointed out, I think he's watching this, that I have a bed behind me and he's waiting for someone to lie in the bed. I am not in my bedroom. I'm in a hotel room. I just want people to know I don't usually do Zoom calls in my bedroom. So
yeah, tell Bill to stay out of your business.
Yeah, exactly.
From the jury's vantage point, the defense attorneys were all on the same team. And Kevin, who represented Roddy, made a point kind of repeatedly to take issue with the fact that members of Arbery's family brought nationally prominent black pastors into the courtroom. And then Linda generated a fair amount of publicity with her kind of physical descriptions of the defendant.
No, Laura. Not
Laura.
Laura, I mean, I'm sorry. When you're gathering at the end of the day, and you're all representing different defendants, but you're all supposedly on the same team, what's that conversation like? Were you all aware that that was going to happen, that those kinds of things and those statements were going to get made, or that was going to happen in advance, or did that happen?
No. If we could have slapped a piece of duct tape on Kevin's mouth at that moment, we would have. What Kevin was saying, and he's not wrong, necessarily. It's the way he said it. But what he was saying at the time was, Judge, you know, when a police department feels strongly about a particular case, you would see in the past, you know, 20 police officers sitting in the gallery sending a message to the jury. That has happened multiple times in our history. And what he was trying to say was that having Jesse Jackson and Al Sharpton, famous, you know, civil rights activists, sitting with Ahmaud Arbery's parents, was sending a message to the jury that, you know, do the right thing as we view it, or there could be trouble. I think that's what he was trying to say. The way he said it was extremely unfortunate and just created more problems than anything that was happening before that. He didn't need to phrase. I mean, the art of lawyering is the art of speaking. I don't know why he was not better at doing his job that way. It was very frustrating, and also, again, created. I'm like the next day or 2 days later, the new Black Panther Party with their AK-47s and their camouflage were, you know, or their military uniforms were out there. That upped the fear factor for people in the courthouse. So, was it helpful? No. Was he trying to do something right for his client? Yeah, I think I won't ascribe bad motives to him. Same with Laura Hogue's comment in closing. If you follow the case, first of all, if you know Laura Hogue, she's the most progressive, loveliest, well-meaning person on the planet. And I know her very well. And she would never make a remark purposefully that was a dog whistle to racist jurors. Number one, we didn't have racist jurors. None of us had any reason to believe that any of the jurors would be responsive to a dog whistle. So there was no reason for her to phrase something in a way that would appeal to racism. What she was trying to do was quote the medical examiner from his autopsy report, who noted that Ahmaud Arbery was unkempt at the time of his death, at the time of the examination, and was trying to juxtapose that view of Mr. Arbery with the big smile, beautiful face photograph that the state used in the trial to depict Mr. Arbery. That was not the person that was seen on February 23rd, 2020. And she was trying to, without getting into his mental health records or his prior criminal history or his lack of jogging in the neighborhood. Well, she was getting the lack of jogging, but not the other stuff, artfully trying to describe him to show the jury that he was not who the state had depicted him to be. Was it a cringe-worthy moment? Yes, we all kind of cringed as it came out, and it was cringe-worthy because she's so good at articulating, at arguing, at putting phrases together, that it was really powerful when she said that. Did the jury look at it as a dog whistle? I doubt it. I think it probably went, right past them. It was the audience who replayed it time and time again, who saw it for what it wasn't. And she's taken unbelievable heat, even from her own brothers and sisters in the criminal defense bar. I think unfairly. I don't think she had any bad motive at all or racist motive in making that argument.
Yeah. There's another question in our chat from a participant. Was there a single turning point in the trial that likely proved persuasive to the jury? A witness, a ruling, or a piece of evidence?
Linda, you won. You get to answer that question.
The answer is there were three big pieces of evidence for me. The first one was the video of Ahmaud when he's at the open unsecured construction site at Larry English's, and he walks out and you see him take off just casually jogging into the neighborhood. Yes, it's night. Yes, it's after 5 p.m. But there he is. He's actually running in his cargo shorts and his tennis shoes out into Satilla Shores. Okay. And that was a huge piece of evidence of yes, he's actually in Satilla Shores and he's actually jogging. And here's him on video doing it. The next thing for the state was Officer Robert Rash. Robert Rash had body cam video on, and he's telling the McMichaels specifically, Larry English just wants to have a conversation with this guy. He's never stolen anything. He's never taken anything. You know, Greg McMichael says, well, you know, it's trespassing. And Robert Rash is like, well, yeah, it's loitering and prowling. So at this point in time, and this is on February 11th, that piece of evidence, as I repeatedly said in closing argument, is a really, really important piece of evidence, because Robert Rash was like, my intention as a law enforcement officer was simply to put Mr. Arbery on the phone with Larry English. So Larry English, if he wanted to, would go, hey, could you please stop going over there? Because my cameras keep going off. And for all we know, that conversation would have gone, hey, man, I'm really sorry. I won't go over there anymore. We don't know how that conversation would have gone. But instead, there is no conversation. Law enforcement doesn't get there in time, and Mr. Arbery's dead. So those sorts of pieces of evidence, they were, I think, important in our case to illustrate what the McMichaels knew when they knew it and their driveway decision. And a lot of people did, I really do think they really thought that they had seen him go into that house on February 23rd. Like they mistakenly think that he's Mr. Albenze, who's the 911 caller. Mr. Albenze is the one who actually went, I called the non-emergency line because this wasn't an emergency. It's just, he's over there. Can you send somebody out? That's not Greg McMichael. That's another citizen. And Greg McMichael just sees Ahmaud running down the street. So that other piece of evidence, those were kind of the big three, I think, for the state's case.
Yeah, all three of which were used in the federal case that took place during the last 8 days. Bob, we're running out of time, but I think the $100,000 question is also for you. Your client took the stand in his own defense. It's not, the prosecution is the one that has to prove guilt. You don't have to mount a defense. Take us through the conversations you were having and why Travis McMichael decided to take the stand, and what preparation did you give him when that decision was made?
Is this really a $100,000 question?
Ask the Georgia First Amendment Foundation, yes.
Well, in a self-defense case, I think typically a defendant has to take the stand and explain why he was in reasonable fear for his life. In this case, honest to God, I first met Travis with my partner, Jason Sheffield, in May of 2020, right when we were hired. We spent hours with him at that initial meeting. We both walked out of the Glenn County jail and looked at each other and said, this guy's great. I mean, he tells the story in a very believable way, which is not, if you do criminal defense work, that's not always the case. We liked Travis. We thought he came off well when we met with him and when he told his story of what was going on, and he never wavered in the story he was telling us. And we thought from the beginning that he would have to take the stand. The harder question was, and it wasn't for us, but for the other lawyers, was Greg McMichael going to take the stand? And Greg, well, I won't talk about that. So we always thought Travis would take the stand, and I thought he would do well, and I thought he did well. I think Linda did a great cross of him, but I thought he did well. And the proof in the pudding for me was my daughters and my nephew, all of whom wanted me to lose, texted me after he testified saying, I actually feel sympathy for this guy. And that's what we were trying to do.
So that wouldn't be a piece of evidence you would bring up to say that swayed the jury against you?
I don't know if, no, I wouldn't think so. I mean, I would think if anything, it was a neutral factor. Some people thought he was cold on the witness stand. He got choked up. I mean, I thought he actually did well. When, and maybe Linda has a different view. I'd love to hear it. When we left for the day, I felt pretty good about it, about at least what he did. I didn't know if we would win or lose, but I felt that Travis handled himself pretty well. Definitely Linda scored lots of points on cross, but we knew that was going to happen. I thought he acquitted himself well on the stand, showed the appropriate demeanor, the appropriate articulation of his worries. And without him, we really couldn't have made our self-defense case.
Yeah. Hyde, how are we on time?
Got about 10 minutes.
All right.
May leave a couple minutes. Let me ask, Linda, I don't know whether you have thoughts on that question as well. Did you think Travis was going to be the one who took the stand or not? Or did you think?
All right, so what we did was this. We divided the 3 defendants and we each decided to become an expert on each of the defendants. Okay, and so that was our plan. You'll notice Larissa took like all of Mr. Bryan's kind of witnesses, Agent Seacrest. Paul dove really, really deep into all the social media for Travis McMichael and everything. And I was focused on Greg McMichael. I actually believed that if anyone was going to take the stand, it would be Greg McMichael. I thought that he, as a former law enforcement officer, might want to pitch to the jury his side and then also wrap in Travis's side and sort of do that sort of appeal from his point of view. However, after opening statements, it became very obvious that he was not going to take the stand. That was, Frank Hoag's opening. I thought, oh, Greg McMichael's not testifying. Mr. Bryan's not testifying. Travis is testifying. So at that point, after opening, we completely pivoted into focusing in on Travis McMichael and the cross-examination for him. But we were prepared for all 3. We had no idea what was going to happen.
Let me ask you one more. You put a good bit of emphasis on driveway decisions, and you kind of avoided the whole issue of race until your closing, really. And all the while you're talking to the family, who was very convinced that race was a big driver in this case, so much so that they declined to accept guilty verdict and wanted a trial in the hate crimes case. How did they react to your approach, your strategy not to kind of lean into race on the case?
They were fine with it. I think you got to realize that the family had been through a number of things before we ever got it on May 11th of 2020. Obviously, Barnhill, Tom Durden of the Atlantic Judicial Circuit had been in contact with them. The video gets released. Tom Durden does the right thing. I can't, he doesn't have the resources. He recuses himself. The GBI is brought in, and then we're given the case. So at this point in time, remember, it's also COVID. So normally we'd have those face-to-face kind of meetings with the family, and we're in Cobb. Mr. Arbery's down in Brunswick. Miss Wanda Cooper Jones is not even in Brunswick. So we were mostly doing a lot of these things by phone. So when we first were strategizing about the case, we didn't know what we were going to do. We were really strategizing about it in 2020. We got through motions through January 31st. We had to file responses to motions in preparation for the motions hearings in May. And during that entire time, that's still strategy time. And that's still the lawyers working. So while we're in communication with the family, we really haven't gotten where our strategy is going to be, because we hadn't gotten orders from the judge as to what evidence was going to be in and what evidence was going to be out. And those rulings really help inform our strategy. Now, as far as once we had made the decision at trial, we told them these are our decisions and this is what we're doing. But keep in mind, they knew at that point in time that the federal indictment had come down, that they had been charged federally with hate crimes, and they knew that there was going to be the second case out there that that was in regard specifically to those hate crimes. So when we said, listen, our strategy is that we don't have to prove this, we don't have to prove motive. And the minute we put this in, and like I think Bob said earlier, his argument was going to be, I can't correlate Travis's social media with his intent to murder Mr. Arbery. Okay. And I thought that was a great line. He just said that earlier today. And that was, I'm assuming, going to be his argument. And I knew that was going to be the argument. They're going to get up here and they're going to argue a bunch of really bad texts has nothing to do with what took place on the 23rd. And that's not a bad argument. I didn't need to prove it. So if I don't need to prove it, disappointment often equals reasonable doubt with the jury. There was no reason to disappoint the jury because I didn't need to prove their motive in the murder. I just needed to prove their intent and their intention to commit the crimes they'd been charged with.
Bob, was the defense at all surprised by the kind of lack of attention to racial animus or not?
Yeah, I mean, we had pretrial motions filed by the state indicating they wanted to get into it. And it wasn't until kind of the very end, right before trial, where they withdrew their 404B motion, their motion to get into the social media and text messages and things for the defendants. And we were relieved. I mean, certainly that was one less battle to fight. We had enough battles without that one. And it's interesting. The prosecutor in the George Floyd case did the same thing. I don't believe in the prosecution of the officer Chauvin, there was any mention of the races of the defendant and the victim. And I thought Linda was smart to take that off the table and not create one more really war that we'd have to fight and the jury would have to decide one way or another on. But we were relieved not to deal with that.
If we have time for one more question, I will take my moderator's prerogative and ask something a little bit more introspective about the criminal justice system at large and the agencies within the criminal justice system, starting with local law enforcement, in this case, the Glenn County Police Department, local district attorney's office, and I'd like to ask each of you, I mean, the hypothetical of would this case be different if there were different genders or different races? Would this case have been different if the Glenn County Police Department had arrested people on the scene? If there was arrests made and what we all consider a more usual procedure in place, that charges are brought or not brought in a timely fashion, that the investigation doesn't get derailed for whatever reason it was derailed for 74 days. What do y'all think about that? The role that law enforcement, or the lack thereof, played in getting us to where we are?
All right, so first off,
no, excuse me.
you want me to go? Sorry.
Go ahead.
This wasn't Glenn County Police Department's problem or fault at all in any way, shape, or form.
Okay.
They pulled up on the scene. They took a look at it. They did their best to figure out what in the world was going on in officer safety. They then did what they needed to do, which is reach out to the district attorney's office, which Jackie Johnson went, I'm recusing myself.
Yep.
I can't do anything like this. The next DA came in and took one look at the evidence, and basically, in my opinion, this is what happened. He came in, went, yeah, this is self-defense, that's fine. With no investigation, no GBI, no nothing. And at that point, once a law enforcement agency has been told by the new prosecutor, I'm not going to file charges, they don't continue trying to investigate the case. They've been told by this prosecutor, yeah, I think this is what my decision is, okay? And that, I think, stalled it unbelievably. And we have Wanda Cooper Jones to thank for pushing the fact that DA Barnhill may not have been the correct person due to that conflict of interest, his son working in that office. Then Tom Durden got it, and he made the right decision. He called the GBI in. And once the GBI came in, he realized, I don't have the resources to do this either. And I know that the Glenn County Police Department got a lot of criticism for that, but in my opinion, having come from Fulton County, there's a way to do this and there's a way not to do it. And the way not to do it was what happened here. We eventually got on the right track, but it certainly wasn't the law enforcement officer's fault for that. That's just my opinion on how that went down.
Bob, what's your take?
Well, it's going to be really interesting because there's still one trial left to be had, and that is Jackie Johnson's trial. And, you know, if you read the indictment of Jackie Johnson, it is a mess. It is very unusual, to say the least, to have alleged to have violated your oath of office by not treating the Arbery family with respect. I don't even know what the law is that supports that. So Ms. Johnson has very good counsel. I don't know when that trial will move forward, if it ever moves forward, honestly. But
I spoke to the Attorney General's office at the end of January. They told me the investigation is still ongoing. No trial date is set.
Yeah, there's not. I mean, I know from talking to defense counsel that they haven't received any discovery yet. So I think that tells you a little bit about the quality of that indictment. To indict someone and then still do your investigation, I think, is a little problematic, especially given the 1.5 years or 2 years now that have passed.
Mhm.
So I don't know if the DAs, Mr. Barnhill in particular, had handled this differently, or the police just made the arrests. I mean, police don't always call the DA's office before making an arrest. They just make an arrest. Why they felt like they had to call Miss Johnson, I think it was because it was an ambiguous scene. There was certainly a man dead in the road, and there were 2 guys standing over him with guns, or recently having had guns. But there was also all this conversation about him being in the neighborhood at all times before, and he attacked the guy with the gun before, and then they looked at the video. I think it was confusing. I think the case was confusing, which was why I think it's interesting. I mean, I think the facts, it's like a law school problem. The more we dug into it, the more it could be viewed from all different sides. So I don't fault the Glenn County Police either. Mr. Barnhill's involvement is unique. And I'm not sure if he did something differently, whether that would have, made the case, go differently down the road.
One small thing to note for everyone who doesn't live in coastal Georgia: the week after Ahmaud Arbery was killed, the chief of police and 4 other Glenn County Police Department officers were indicted themselves on separate criminal charges. Have nothing to do with this case, but there was definitely a leadership vacuum within that police department at the time that this investigation was ongoing.
There's a history of problems in Glenn County, that's for sure.
Yeah.
All right, I'm going to turn it over to Richard because I think he has closing remarks. I want to thank you all again, Judge Colbert, Robert, Linda. I really appreciate your time, and I know the audience does as well. Richard, do you want to take over?
Thank you for an incredibly informative session. I really learned so much. This has been the first of 6 sessions for this conference. I want to remind everyone that we start at 2 o'clock tomorrow with a panel on what's going on, parents, the press, and public education. It's organized by Meredith Kincaid and Sarah Brewerton Palmer. The AJC's Maureen Downey will lead a discussion with ProPublica's Nicole Carr, the Atlanta Public Schools Jason Estevez, and Timmy Foster of Parkside Elementary. Again, that's 2 o'clock tomorrow. We'll also have another session on communicating in the disinformation age at 3:30 p.m. On behalf of the conference, thank you for joining us. We'll look forward to seeing you again at 2 o'clock tomorrow. Thanks so much.